Rule 51. Judgment. Section 1. When case deemed submitted for judgment. A case shall be deemed submitted for judgment. A. In ordinary appeals. 1. Where no hearing on the merits of the main case is held, upon the filing of the last pleading, brief, or memorandum required by the rules or by the court itself, or the expiration of the period for its filing. 2. Where such a hearing is held, upon its termination or upon the filing of the last pleading or memorandum as may be required or permitted to be filed by the court, or the expiration of the period for its filing. B. In original actions and petitions for review. 1. Where no comment is filed, upon the expiration of the period to comment. 2. Where no hearing is held, upon the filing of the last pleading required or permitted to be filed by the court, or the expiration of the period for its filing. 3. Where a hearing on the merits of the main case is held, upon its termination or upon the filing of the last pleading or memorandum as may be required or permitted to be filed by the court, or the expiration of the period for its filing. N. Section 2. By whom rendered. The judgment shall be rendered by the members of the court who participated in the deliberation on the merits of the case before its assignment to a member for the writing of the decision. N. Section 3. Quorum and voting in the court. The participation of all 3 justices of a division shall be necessary at the deliberation, and the unanimous vote of the 3 justices shall be required for the pronouncement of a judgment or final resolution. If the 3 justices do not reach a unanimous vote, the clerk shall enter the votes of the dissenting justices in the record. Thereafter, the chairman of the division shall refer the case, together with the minutes of the deliberation, to the presiding justice, who shall designate 2 justices chosen by raffle from among all the other members of the court to sit temporarily with them, forming a special division of 5 justices. The participation of all the 5 members of the special division shall be necessary for the deliberation required in Section 2 of this rule, and the concurrence of a majority of such division shall be required for the pronouncement of a judgment or final resolution. 2a. Section 4. Disposition of a case. The Court of Appeals, in the exercise of its appellate jurisdiction, may affirm, reverse, or modify the judgment or final order appealed from, and may direct a new trial or further proceedings to be had. 3a. Section 5. Form of decision. Every decision or final resolution of the court in appealed cases shall clearly and distinctly state the findings of fact and the conclusions of law on which it is based, which may be contained in the decision or final resolution itself, or adopted from those set forth in the decision, order, or resolution appealed from. Sector 40, BPBLG 129, N. Section 6. Harmless error. No error in either the admission or the exclusion of evidence, and no error or defect in any ruling or order or in anything done or omitted by the trial court or by any of the parties is ground for granting a new trial or for setting aside, modifying, or otherwise disturbing a judgment or order, unless refusal to take such action appears to the court inconsistent with substantial justice. The court at every stage of the proceeding must disregard any error or defect which does not affect the substantial rights of the parties. 5a. Section 7. Judgment where there are several parties. In all actions or proceedings, an appealed judgment may be affirmed as to some of the appellants, and reversed as to others, and the case shall thereafter be proceeded with, so far as necessary, as if separate actions had been begun and prosecuted, and execution of the judgment of affirmance may be had accordingly, and costs may be adjudged in such cases, as the court shall deem proper. 6. Section 8. Questions that may be decided. No error which does not affect the jurisdiction over the subject matter or the validity of the judgment appealed from or the proceedings therein will be considered unless stated in the assignment of errors, or closely related to or dependent on an assigned error and properly argued in the brief, save as the court may pass upon plain errors and clerical errors. 7a. Section 9. Promulgation and notice of judgment. After the judgment or final resolution and dissenting or separate opinions, if any, are signed by the justices taking part, they shall be delivered for filing to the clerk, who shall indicate thereon the date of promulgation and cause true copies thereof to be served upon the parties or their counsel. N. Section 10. Entry of judgments and final resolutions. If no appeal or motion for new trial or reconsideration is filed within the time provided in these rules, the judgment or final resolution shall forthwith be entered by the clerk in the book of entries of judgments. The date when the judgment or final resolution becomes executory shall be deemed as the date of its entry. The record shall contain the dispositive part of the judgment or final resolution and shall be signed by the clerk, with a certificate that such judgment or final resolution has become final and executory. 2a. R. 36. Section 11. Execution of judgment. Except where the judgment or final order or resolution, or a portion thereof, is ordered to be immediately executory, the motion for its execution may only be filed in the proper court after its entry. In original actions in the Court of Appeals, its writ of execution shall be accompanied by a certified true copy of the entry of judgment or final resolution and addressed to any appropriate officer for its enforcement. In appealed cases, where the motion for execution pending appeal is filed in the Court of Appeals at a time that it is in possession of the original record or the record on appeal, the resolution granting such motion shall be transmitted to the lower court from which the case originated, together with a certified true copy of the judgment or final order to be executed, with a directive for such court of origin to issue the proper writ for its enforcement. N. Rule 52. Motion for a reconsideration. Section 1. Period for filing. A party may file a motion for reconsideration of a judgment or final resolution within 15 days from notice thereof, with proof of service on the adverse party. N. Section 2. Second motion for reconsideration. No second motion for reconsideration of a judgment or final resolution by the same party shall be entertained. N. Section 3. Resolution of motion. In the Court of Appeals, a motion for reconsideration shall be resolved within 90 days from the date when the court declares it submitted for resolution. N. Section 4. Stay of execution. The pendency of a motion for reconsideration filed on time and by the proper party shall stay the execution of the judgment or final resolution sought to be reconsidered unless the court, for good reasons, shall otherwise direct. N. Rule 53. New trial. Section 1. Period for filing, ground. At any time after the appeal from the lower court has been perfected and before the Court of Appeals loses jurisdiction over the case, a party may file a motion for a new trial on the ground of newly discovered evidence which could not have been discovered prior to the trial in the court below by the exercise of due diligence and which is of such a character as would probably change the result. The motion shall be accompanied by affidavits showing the facts constituting the grounds therefor and the newly discovered evidence. 1a. Section 2. Hearing and order. The Court of Appeals shall consider the new evidence together with that adduced at the trial below, and may grant or refuse a new trial, or may make such order, with notice to both parties, as to the taking of further testimony, either orally in court, or by depositions, or render such other judgment as ought to be rendered upon such terms as it may deem just. 2a. Section 3. Resolution of motion. In the Court of Appeals, a motion for new trial shall be resolved within 90 days from the date when the court declares it submitted for resolution. N. Section 4. Procedure in new trial. Unless the court otherwise directs, the procedure in the new trial shall be the same as that granted by a regional trial court. 3a. Rule 54. Internal business. Section 1. Distribution of cases among divisions. All the cases of the Court of Appeals shall be allotted among the different divisions thereof for hearing and decision. The Court of Appeals, sitting en banc, shall make proper orders or rules to govern the allotment of cases among the different divisions, the constitution of such divisions, the regular rotation of justices among them, the filling of vacancies occurring therein, and other matters relating to the business of the court, and such rules shall continue in force until repealed or altered by it or by the Supreme Court. 1a. Section 2. Quorum of the court. A majority of the actual members of the court shall constitute a quorum for its sessions en banc. 3 members shall constitute a quorum for the sessions of a division. The affirmative votes of the majority of the members present shall be necessary to pass a resolution of the court en banc. The affirmative votes of 3 members of a division shall be necessary for the pronouncement of a judgment or final resolution, which shall be reached in consultation before the writing of the opinion by any member of the division. Section 11, first paragraph of Batas Pambanza BLG 129, as amended by Section 6 of Executive Order 33, 3a. Rule 55. Publication of judgments and final resolutions. Section 1. Publication. The judgments and final resolutions of the court shall be published in the official gazette and in the reports officially authorized by the court in the language in which they have been originally written, together with the syllabi therefore prepared by the reporter in consultation with the writers thereof. Memoranda of all other judgments and final resolutions not so published shall be made by the reporter and published in the official gazette and the authorized reports. 1a. Section 2. Preparation of opinions for publication. The reporter shall prepare and publish with each reported judgment and final resolution a concise synopsis of the facts necessary for a clear understanding of the case, the names of counsel, the material and contract overt points involved, the authorities cited therein, and a syllabus which shall be confined to points of law. Sector 22A, RA number 296, N. Section 3. General makeup of volumes. The published decisions and final resolutions of the Supreme Court shall be called Philippine Reports, while those of the Court of Appeals shall be known as the Court of Appeals Reports. Each volume thereof shall contain a table of the cases reported and the cases cited in the opinions, with a complete alphabetical index of the subject matters of the volume. It shall consist of not less than 700 pages printed upon good paper, well bound and numbered consecutively in the order of the volumes published. Sector 23A, RA number 296, N.